Hi, my name's Abigail Paul. I am a third year law student at the WVU College of Law. I'm also a student attorney in the WVU College of Law Clinic. I'm a MSW student as well. I'm finishing up both this year, and I'm also working as a social worker within the law clinic.
And hello, my full name's Ethanuke, but I go by Nuke for short. I'm currently an MSW student and I am interning at the law clinic with the lovely Abigail, and we'll be presenting to you guys today.
And I will briefly introduce myself. I'm the clinical director for the General Litigation Clinic. So I'm working with Abigail and Nuke on a regular basis, and they've done the work to put together this presentation together.
All right, I'll go ahead and get started. So today we're going over a case that was decided by the West Virginia Supreme Court in 2023 that had an impact on what is considered abuse and neglect of a child under West Virginia law. This case is called In Re SCKR and EH. And then I was just going to quickly flag that the reason the case name is like that is because in cases that involve children, the court uses their initials instead of their full names to protect their privacy. So that's why it's initials. And then the phrase in re just essentially means like in the matter of. So essentially, the Supreme Court of West Virginia is reviewing a case that involved these children. And specifically in this case, it was an abuse and neglect case. You guys can go ahead to the next slide. So I'm going to quickly as possible go over the process and procedures for an abuse and neglect case from beginning to end. This will just be a broad overview. These proceedings are a little more complex than what I'm going to mention, but this is just like the gist of it so that when we go through the case, you'll kind of understand what's happening. So, the first step before the courts become officially involved, abuse and neglect cases begin when a report is made to Child Protective Services. These reports usually come from mandatory reporters. So in West Virginia, this includes doctors, nurses, teachers, law enforcement, social workers, and a few other categories of people. So most people here probably know what it entails to be a mandatory reporter, but I'm just going to flag that just in terms of like legal language, all that is required that is a reasonable belief that a child may be being abused or neglected. So that essentially means that if you have a reason to believe that a child may be being abused or neglected, you're legally required to report it to the West Virginia Department of Human Services within 24 hours of um, becoming aware of these circumstances. So then once CPS receives a referral, they will screen it and decide if the accusations kind of meet the definitions of abuse and neglect. And if they do, they assign a worker to do further investigation. During that investigation, the CPS worker will meet with the family and the child, and they assess whether they believe the child's safety is at risk. So, depending on the level of risk, the worker may put into place what's called an in-home safety plan, that basically just sets out terms and conditions that the family should follow in order to guarantee the child's safety, and that allows the child to stay and remain in the home while they continue to work with the family. If the safety plan is not followed, or from the get-go, the CPS worker finds that the child's safety is too at risk to remain at home, they'll seek court intervention. So, prosecuting attorneys are assigned to act as the Department of Human Services attorney, which is what CPS is under, Department of Human Services. And then, so just moving forward, I'm just going to refer to them as the department because it's a little easier, and that's kind of typically how they're referred to during these cases. So the prosecuting attorney will write up a petition to ask the court to bring abuse and neglect proceedings against the offending parents. So the petition has to outline certain conditions that are present in the case that support the department's allegations against the offending parents. So I won't get too far into details about what these are required to look like, but they are outlined by West Virginia law. And this is when the legal system officially becomes involved. You can go to the next slide. So after a petition is filed with the circuit court, and I'm just going to note here real quick that these proceedings do happen in circuit court, which is where like criminal and civil cases kind of live, not family court, despite the fact that it involves families. But also at the same time, these cases are not considered criminal cases. The purpose of these cases isn't to put someone in prison or probation or have them pay a fine or anything. Although there are elements of these types of cases that somewhat resemble like what a trial may look like. So the first step is a preliminary hearing, and that is when the department, through the prosecuting attorney, has to show enough evidence that would warrant further proceedings, which is a pretty low requirement to meet. But at this point, just because a judge decides there's enough evidence to proceed to the next step of the case, it doesn't mean that they are declaring that the parents are abusive and neglectful at this point. It just means there's enough evidence to warrant a hearing that will look more closely at it and then make a decision. And additionally, also at this point of the case, the department can begin offering services to the family, which are typically like therapeutic services, anger management, if that's an issue, parenting classes, stuff like that. So the next step is an adjudicatory hearing. This part of the case, this is the part of the case that kind of resembles like what you might think of when you think of a trial. So this is when the court will officially decide whether abuse or neglect has occurred. So the department will present evidence and testimony to try and show that the parents were abusive and neglectful. And then the parents, who also are appointed attorneys to defend them during this case, they will get to a chance to try and prove that they were not abusive or neglectful to their children. So if the court does find that there is abuse and neglect, the court will set up what is called a dispositional hearing, which I'll explain a little more in a second. But between the adjudicatory hearing and the dispositional hearing, the parents will need to participate in an improvement plan. And this includes a list of terms and conditions that the parents need to follow and services that they need to participate in. And again, this is usually stuff like therapy, parenting classes, anger management. And then if there's been alcohol abuse or substance use, they will likely require the parents to regularly drug test, or they can have them test for alcohol use as well. And then at the end of their improvement period is when the dispositional hearing is held. This hearing reviews the parents' progress with their improvement plan and determines whether or not they've made enough improvement to return the child back into their custody. So it's basically kind of like whether or not it's safe for the child to return to their parents. If it's found that it's not safe, for the child to return, the court can either terminate the parental rights, or in a decent amount of cases, they extend the parent's improvement plan if they think that there's a good chance that given some extra time, the parents will be able to improve. And you can go to the next slide.
And now I'm going to talk about the statutory definition for abuse versus neglect in West Virginia. So starting with abuse. So abuse is classified as an abused child is defined as a child whose health or overall well-being is being harmed or threatened. Abuse involves a parent, a guardian, or custodian who knowingly or intentionally causes harm or allows someone else to cause harm to the child. So this harm can be physical, it can also be mental or an emotional injury. Also something to note is that domestic violence that is witnessed by the child and impacts the child can also be considered abuse if it is done in front of the child. And then the definition for neglect. So a neglected child is one whose physical or mental health is harmed or put at risk because of a parent, guardian, or custodian. or a custodian who fails or refuses to provide basic necessities to the child. So these can include food, clothing, shelter, supervision, or medical care or education. Something also important to note that these situations do not involve poverty. So poverty alone is not considered neglect, which is something important to note. And a child also may be considered neglected if they lack basic needs due to the absence or disappearance of a parent or custodian. And you can go to the next slide. And now we're going to talk about the statutory code versus the legal interpretation. So the statutory code is the written law. It is what defines abuse and neglect and sets the official rules. A legal interpretation is how the courts apply those rules to real life situations using case law to clarify and guide decisions. So when looking at legal interpretation, in abuse cases, the focus is on intentional harm or injury to the child. In neglect cases, the focus on whether the child was exposed to risks due to inadequate care or supervision. Court cases involving neglect do not wait for actual harm to happen. The goal is to try to protect the child from foreseeable danger. So just to kind of put this all together, the statutory code provides the foundation by defining abuse and neglect and outlining all of those legal standards. However, legal interpretation gives those statutes real meaning. For example, through appellate court decisions, judges clarify how the law should be applied in real life situations and establish guidance for future cases. In both abuse and neglect matters, courts rely not only on written statute, but also on controlling case law to ensure children are protected from intentional harm and foreseeable risks as well. And you can go to the next slide, please.
So, in this case, in a Supreme Court case in general, a West Virginia Supreme Court case, the court is reviewing a case that was originally held in the circuit court, and they're deciding whether or not that court made a mistake by applying the law wrong, basically. So I'm going to go over the facts from the original abuse and neglect case that kind of started all this. So the case began when a mother gave birth to a child whose umbilical cord blood tested positive for a variety of illicit substances. So this shows that the mother was using drugs during her pregnancy. In West Virginia, this is considered abuse and can result in the child being removed from the parent's custody. That's what happened in this case. The department removed the child from the mother's custody. This also resulted in the removal of her other children from the household, from her custody, because generally when one child in a household is found to be abused or neglected, the department can remove the other children from the household as well, because there are safety concerns for these other children.
What's going on?
Okay. So the children were then placed with their biological father, who, it seems from this case, was not currently in a relationship with the mother and was not living with her. However, at the preliminary hearing for the abuse and neglect proceedings against the mother, it came to light that the father was using methamphetamine and some other illicit substances, and this resulted in the department removing the children from his custody as well, and they brought abuse and neglect proceedings against him too. So they then gave him certain terms and conditions he was to comply with during the remainder of these proceedings. However, he failed to comply with these terms and conditions, which included drug screening to show that he was no longer using. But despite not drug screening and not complying with these terms and conditions, the court still decided to allow him to retain custody of the children because he told the court that he only used these substances when someone else was watching the children or when they were not in his presence. So then the guardian ad litem, who is an attorney that is appointed to represent the children in these cases, they appealed this decision, basically stating that the children should not have been returned to their father because of his continued drug use. You can go to the next slide. So the Supreme Court of West Virginia then had to review the case and decide whether a parent who chronically uses methamphetamine while acting as a child's physical and primary custodian endangers the child's well-being and therefore meets the legal definition of being a neglectful parent under the West Virginia statutory code. You can go to the next slide. So the Supreme Court made the following findings in this case. First of all, just in every abuse and neglect case, the following principle applies. While parents have substantial rights to their children, the primary goal in abuse and neglect cases is the health and welfare of the child. So what is in the best interest for the child's mental and physical health and safety are always the guiding principle in these cases. So the court found that even though the children were not in his presence at the time, they were still in his custody, and he was ultimately responsible for their well-being. Therefore, parents, they remain responsible for supervision at all times, even if a caretaker is temporarily involved. The court also noted that it's well known that methamphetamine's effects on parenting threaten the child's well-being. Now, the court noted that there was a previous West Virginia Supreme Court case that established that just substance use by a parent on its own doesn't always constitute neglect unless it's linked to harm or a threat of harm to the child. But in this case, that did not apply because the father abused methamphetamine while serving as the child's physical and primary custodian. So the court ruled that the father's chronic drug use made him a neglectful parent because under West Virginia code, a neglected child is one whose physical health is harmed or threatened by a parent's refusal or inability to provide necessary supervision. So even though the father did not take the drugs in front of the kids, the effects of the drugs overall made him unable to provide necessary supervision of the kids. And this is especially true of substances like methamphetamines because unlike drugs like marijuana, there's no level of methamphetamines that can be considered to be like a therapeutic dose or a therapeutic level that allows them to be able to take it and then still be able to function regularly. And you can go to the next slide. So the main takeaway from this case is that West Virginia case law has found that a parent who chronically uses methamphetamine while acting as a child's physical and primary custodian endangers the child's well-being, even if they're not taking drugs while the children are, even if they're taking the drugs while the children are with a third party or not in the parent's presence. So therefore, that type of drug use meets the legal definition of a neglectful parent under the West Virginia statutory code. You can go to the next slide.
And now I'm going to discuss how this is going to impact practice, both on a legal sense and also for social workers or other health practice professions. So starting just from the legal lens, so this is going to affect how we evaluate parent behavior. Guardian ad litem must carefully assess parental actions, even when children aren't present, because these observations can influence court decisions on neglect, as Abigail just stated. And then also, this is going to change a little bit legally, understanding neglect standards. Lawyers and CPS attorneys need to recognize that chronic substance use alone can legally qualify as neglect. So this is going to shape case strategy and evidence collection. It's also going to require some more monitoring and documentation. Court rulings show that attorneys must consistently monitor cases, carefully document everything, and clearly report whether the parents are meeting court requirements. From a legal standpoint, strong and detailed records are essential. They can be used to either support the court's findings or even to challenge them as well. And it's also going to affect legal responsibility during temporary custody. So even if a child is staying elsewhere temporarily, the parents will remain legally responsible. Because of that, attorneys need to clearly advise their clients about their responsibilities and make sure supervision arrangements are properly documented. And then also, this is going to change legally, balancing child welfare and parental rights. Appeals often hinge on whether courts appropriately weigh child welfare over parental rights. So legal professionals must frame their arguments with both statutory definitions and child safety priorities in mind. And then now we're going to look at this law more from a social work and health practice lens. So recognizing risk is going to be a big aspect of this. Social workers, nurses, and other professionals must understand that parental substance abuse can threaten the child's well-being, even if the child is not present during that use, according to the law. Same thing with risk and assessment. This case highlights the importance of thorough risk assessments and ongoing monitoring, and then just collaborating with other legal authorities as well. And lastly, this case just shows that protecting children isn't just about reinforcement and enforcement, it's about collaboration. Professionals must support parents' safety while keeping children protected, and everyone, including courts, CPS, social workers, and healthcare providers, must communicate and work together. And that strong teamwork and clear records are key to making sure families get the help that they need. And you can go to the next slide.
So you actually have a question in the chat. It says, what levels of
Alcohol.
alcohol or THC are considered non-threatening to child's well-being?
I'll kind of take that one. And I guess what I'm going to caveat this by saying that's really going to depend on so many factors. It depends on what judge you're in front of. It's going to depend on the social workers investigating the case. It's also going to depend on whether or not there have been ill effects due to that substance use. So like with alcohol, in my experience, alcohol is one of the trickiest things to deal with in an abuse neglect case because its use is legal. If you're a legal adult, you're allowed to use alcohol. So historically, in my experience, where you see judicial intervention with alcohol use is really where there has been an incident that has affected the well-being of the children. So, for example, domestic violence in the home that law enforcement has been involved in, if there is an underlying alcohol abuse issue, often that will come out. A DUI with children in the car, things like that. When that is the case, where alcohol is an issue, generally speaking, the courts that I've worked in have a zero tolerance policy for continued alcohol use. So once a parent has been adjudicated of having an alcohol dependence or abuse issue, the court is going to say, I will not tolerate any level of alcohol use by this person. What I've been seeing more often in the past few years are the continuous alcohol monitors. I've also seen a fair number of cases where someone can afford it using, and I'm blanking on the name of it, the little devices that you blow into and it takes, like it attaches to your phone and it takes a screenshot of your face blowing into it, and then that gets sent to whoever you've designated as the appropriate person to receive that. Um, with THC, that is a minefield right now. And I saw that that's, I think, next week. The Echo session dealing with that is timely. In West Virginia in particular right now, but really, I think you could say this for a lot of states, it's a very gray issue because we have quasi-legality now with medical marijuana being legal. Recreational obviously is not. We have a split of authority in regards to possession of the non-regulated, I don't know, the stuff you could buy at like a gas station. The Delta 8, Delta 9 variety, technically that's illegal to possess in West Virginia. However, we also have code sections detailing how to sell it legally. And so there is a split right now, and what I'm seeing, there's a lot of difference between counties on how they deal with that, specifically talking about Delta 8, Delta 9. When you talk about the medical marijuana, when people have the license to use that, again, different judges treat that differently. As most of you who are here today know, that's not a prescription. It's not, I'm not going to my family doctor and they're not writing me a prescription for that. And so a lot of judges that I've seen will frequently say you just can't use that, regardless of whether you have a license for it or not. If it's presented enough of a problem that you are in the midst of abuse and neglect proceedings for your children, obviously something generally has prompted that, like something has fallen through the cracks. And I'm not going to say that that's across the board, because I've also seen cases where people have been able to continue to utilize it. I think judges are really they're looking into that pretty deeply. Whereas, like, if I have a Xanax prescription for severe anxiety, as long as I bring in that prescription and my doctor says, yeah, she's prescribed it for anxiety, the judges aren't going to typically look too far beyond that unless it's obvious I'm getting it from several different providers or something like that. Whereas with THC, they'll say, isn't there something else that you could take that the FDA regulates that we can monitor a bit more closely? So that was okay. Yeah, apparently that answered it. So thank you.
And thank you, Jennifer. And we'll just get back on track with this. So we're going to talk about kind of some of the legal positives of this case and maybe some criticisms and some potential challenges. So some positives of the result of this proceeding was that this case reinforces the principle that child safety and well-being come before parental rights in abuse and neglect situations. So this does truly put the child's welfare first. This also gives a clarification for the neglect standards. It establishes that chronic substance abuse by a caregiver can legally be considered neglect. So again, this just gives a clarifying legal standard for this. It also gives a guidance for professionals. This case provides clear guidance for courts, CPS, and social service professionals on how to hold parents accountable while prioritizing child safety. And it also supports guardian ad litems. It emphasizes the role of the guardian ad litem in advocating for children and ensuring their best interests are represented in court. However, on the other side of things, there are some criticisms, like I said, and maybe some potential challenges that could come up with this new proceeding. So parents' rights and concerns. So some argue that this approach may infringe on parental rights, especially if parents believe they are careful not to directly expose their children to substance use. It can also get tricky when determining a threat of harm can be subjective. Interpretations may vary among judges. I think that Jennifer did just touch on that a little bit about how judges kind of decide that decision. And then it could impact on parents seeking help. So parents who are in recovery or struggling with substance use might feel discouraged from seeking treatment out of fear of losing custody. So I was really thinking about this from a little bit of more a social work and kind of health professional lens. So I went ahead and came up with an example of how this could impact this. So for example, a parent recovering from an opioid addiction goes to a clinic for treatment and regularly meets with their nurse and counselor. They worry that disclosing their substance use could lead to a CPS report. One day, the parent misses an appointment due to withdrawal symptoms. Even though they are actively seeking help, the nurse must document and report the situation, which could trigger a child welfare investigation. So this highlights the tension between supporting parents' health and protecting children, and why clear communication and collaboration among health professionals and courts is really going to be essential. So again, sometimes legal rules don't match the reality of supporting families, especially from a social work perspective. For example, a social worker might want to keep a child safely at home while helping a parent with addiction treatment, but the law or court decision may require temporary removal. This shows the challenges, again, of balancing legal requirements with practical family support. So again, this could just be a challenge that could come up with this new law. And just to conclude that, so as we can see, the case brings both clear benefits and some challenges. Like I said, it reinforces child safety and that comes first. It clarifies neglect standards, and it does provide a good amount of guidance for professionals. At the same time, it can highlight tensions between parental rights, court's decision, and the delicate balance between supporting parent recovery and protecting children at the same time. So these are just some aspects to keep in mind when kind of understanding the impact on practice that this new law has. You can go to the next slide.
All right, and you have another question. It said, did chronic get defined in this case?
So in this case, they did not like specifically outline like what chronic meant, but looking at the facts of this case, it was pretty apparent that it was chronic use because if I'm correct, he was using it multiple times a week. So it wasn't just like a once off type of situation where he took it once. This was like a regular, but there could be a case in the future that gets deeper into that and actually goes and defines it.
And I guess what I would say from a practice perspective, like how judges are actually going to generally view that, anything outside of a one-off use is probably going to be seen as problematic. And honestly, even if it's just one time, if a situation arises out of that one time of use that puts those children at risk, that's probably enough to pursue an adjudication in that case. I also just saw a question about alcohol use. I'm sorry, what was that? Um,
Who determines if a parent has an unhealthy relationship with alcohol?
so again, depending on what judge is hearing this, and the facts surrounding it, unfortunately, there's not one specific factual scenario that's going to demonstrate whether or not there's an unhealthy relationship. I think what in practice we would typically expect to see in a situation is where, due to the parent's alcohol use, regardless of quantity, it may be that they have 2 glasses of wine a night, or it may be that they're drinking a handle of Jim Beam every couple days. I don't know, but whatever quantity they're having, if that intake of alcohol creates a risky situation for the children due to the parent's alcohol use, it's going to be enough. So if it's DUIs, either with or without children in the car, leaving children unattended due to alcohol use. So, leaving children who are not at an age to be left at home alone, leaving them in order to go to a bar on a even not a regular basis. If you do it once and something happens, that's going to rise to the level that the judge is going to say that's a risk and probably go to a zero tolerance policy for alcohol in that case.
Yeah, I just wanted to say I appreciate you guys being here because I think this is an important change for everyone to be aware of. And some people kind of have been aware of it and some people haven't. It used to be, and I think actually, Jennifer, you corrected me in an echo that I had given because I was not aware of this change in the law, that it was not merely the presence of use that necessarily indicated a need to report, and this this law really changed some of that, and so it's important to think about and be educated about. I really appreciate you being here